the other guys.
Okay.
They're muted.
Okay. Now you
Okay.
can start.
Okay, good. I'm going to very briefly introduce Candy Morgan to all of you. I could probably take up the whole hour with all her accomplishments, and especially in this area, but I will just do a very brief introduction, and also that just to remind people at the other sites or people logging in that we have muted the participant so that we don't get a lot of feedback from other sites. If you have questions, please type them in to the typing connect, the chat box. Yeah, thanks. So this is Candace Morgan, Candy Morgan. She lives, we're very, very fortunate. She lives here in Portland, Oregon. She has been instrumental in so much of what ALA does with the Freedom to Read Foundation and the intellectual, ALA's Intellectual Freedom Committee. She's currently on the board of the Freedom to Read Foundation, but she has also been a chair in the past for that. And she's been chair of ALA's Intellectual Freedom Committee. She's also very active in Oregon's ACLU chapter, including being past president of that chapter. So that's also something that Candy's been very involved in. And I will now turn it over to Morgan. Thank you.
Before I start, I'm sure you may have heard of some of this, but I'd like to remind you all that the president proposes to eliminate funding for the Institute of Museum and Library Services. The Library Services and Technology Act is the only kind of support for libraries available. As an example of what it will mean in Oregon if this comes is that we have the Intellectual Freedom Clearinghouse, which is in the state library. It's the only one in the country like that. And programs for school libraries, including what they call the Battle of the Books and the Oregon School Library Information System for information literacy. It is very important that you contact your representatives and senators about this and indicate just what really is going to happen with that. And then, as President Trump signs Senate 34 into law, big internet providers will be able to have the power to harvest all of your information without asking your permission and using this if they wish. So that also, this is your internet service provider that would have this. And that is very, very frightening in terms of your privacy. And so you also need to let your representatives and your senators know how unacceptable that is. So, of course, the other thing that's going on in our country right now is a disdain for immigrants. Who founded this country? Immigrants. And the founders sought to develop a governmental structure that would ensure a participatory democracy with protections about takeover by either an authoritative or centralized government. Also a popular majority that would violate individual rights, a tyrannous majority. And the key to that balance they were seeking is a balance between individual rights and individual responsibilities. Where there are no rights, individual responsibility is not necessary. Where individual rights are paramount, individuals must be responsible for their own behavior. The framework that this allows us to is important because it's exactly what the public libraries like to do. Individuals have the right to exercise choice in the selection of what they read, view, or seek information about. They have the right to exercise their choice in privacy, not to be judged by the topics or viewpoints or choices that they make. However, individuals are responsible for how they use those ideas. Libraries are not responsible for how they use it. So it's the individual that is responsible, not the library. What protects our freedoms? Intellectual freedom, the U.S. Constitution and the Bill of Rights, the First Amendment, and state constitutions and bills of rights. And if you have not explored what your state's laws are on that, you should do so. So how do libraries fit into this? Well, libraries have a core mission with three parts: protecting individual rights by providing access to the marketplace of ideas, information in multiple formats, on all subjects, on all points of view, to all people served in the library, regardless of race, nationality, ethnic origin, religion, economic status, or any other arbitrary classification. We serve everyone. And we protect our communities and our country by serving as an inclusive and unbiased source of information and knowledge, which is absolutely essential for a viable democracy. And we protect the right to privacy by balancing the need to collect what we need in order to do our business, and the library user's right to privacy to have private information be not collected unless definitely needed in order to know who has our books checked out, for example. So now, what is the legal status of publicly funded libraries concerning the freedom of speech? The Congress shall make no law. The 14th Amendment applies the First Amendment to states and creatures of the state. Publicly funded libraries are legally creatures of a state government that authorizes their existence. Now, does this mean that everyone in the United States has the same rights? No. The 9th and 10th Amendments allow for those things which are not specifically Congress's right to do. States can make additional rights, and Oregon is one of the states that has done that in most cases. It's, for example, medicinal marijuana, all kinds of various things like that, or up to this, the state is able to do that. How do we know specifically what intellectual freedom rights library users have? The concept of the public forum. The courts have defined a public forum as a place that has been traditionally available, traditionally available for public assembly, speech, and discussion. That's the first kind of a public forum. That's the parks and the sidewalks. That's a traditional one. But then in addition to that, a public forum can be a place that government has designated by policy and practice for free speech purposes based on the mission of the agency. That is called a designated or limited public forum. And that's what libraries are. And there's also a non-public forum, which is not public and not available to the public. So therefore that does not mean that. So what is the meaning of a designated or limited public forum for a publicly funded library? The library may not limit access to constitutionally protected materials solely based on the content or the viewpoint expressed in that material, no matter how offensive that viewpoint may be to a majority of the members of the community. It's viewpoint neutral, is what that is called. Limitations may be placed on time, place, or manner of access to library resources, services, or facilities. The limitation must be absolutely necessary in order to achieve the library's mission. It's called a compelling government need. And there must be no other way to meet that need without restricting speech. Requiring that users return their materials on time is one of those things, so that it will be available for other people to use. Now, any restrictions must be what's called narrowly tailored to meet the very compelling government need. For example, a number of state laws limiting access to internet content in order to protect children have been found by the courts to be unconstitutional because there would be no way to implement the laws with also restricting adult access to constitutionally protected speech. So, what is censorship? Is it selection? If it needs to be done, if it's done in a viewpoint neutral manner, then it's not censorship. Who is a censor? A censor is not a person grieving a library decision. That is a right of citizens to do that. But so, a couple of things that come up in terms of this is FERPA, the Family Educational Rights and Privacy Act. That gives parents certain rights with respect to their children's educational records. And we have to honor that in a way that, in various ways for doing that. These rights transfer to the student when he or she reaches the age of 18 or attends a school beyond the high school level. Students to whom the rights have transferred are eligible students. So, what's the danger of allowing law enforcement access to information about a person's intellectual pursuits without showing probable cause that the person is connected to terrorism or espionage or any other criminal activity? So, third parties are also of concern. For example, doctor and patient medical records, consumer and merchant and financial records, and library records all fall within the category of being private. So we are facing a lot of problems in relationship to having to fight for this, and we obviously need to do something about it. Now, speech versus behavior, as I mentioned before, is also a very big concern. What individual users of the library do after they read our books is their responsibility, not ours. So not all speech is actually covered. For example, and I want to point out right now that pornography is not included in this list. Pornography doesn't have a legal definition, and it is not covered with this. But obscene speech is. In 1973, the US Supreme Court outlined basic guidelines for the trier of fact to determine if a work is legally obscene. And I'm going to read to you what those are, because a lot of people misunderstand this. One, it's whether the average person, who knows what that is, that's my side thing, that's not what it says, applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest. Whether the work depicts or describes in a patently offensive way, sexual content specifically defined by the applicable state law, and whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. The case that determined this was Miller versus California. Now, there's some important factors about the legal definition of obscene speech based on the Miller decision. That was 1973. Important factors are only sexually explicit speech can be found to be obscene. What the court says is we now confine the permissible scope of such regulation to the works that depict or describe sexual conduct. Now, a case called Brockett versus Spokane Arcade in 1985 clarified that the definition of prurient means a shameful or morbid interest in sex. It's a very important indication. Including lust in the definition was termed to be was unconstitutionally overbroad, and that it reached constitutionally protected material that merely stipulated, I'll have to take a glass of water, normal sexual responses. In addition to that, only a trier of fact, which means a jury or a judge, has the legal authority to determine community standards and to establish the other, if either of the other two prongs and the Miller test also apply to a particular work, thus making it unprotected by the Constitution. In the inevitably sensitive questions of fact and law, this is again coming from the court, we must continue to rely on the jury system, accomplished by its safeguards that judges, rules of evidence, presumption of innocence, and other protective features provide, as we do with rape, murder, and a host of other offenses against society and its individual members. While it is illegal to distribute a work that is found to be obscene, it is not illegal to possess it, but you have to keep it to yourself. They can't come and check your house to see. Child pornography. In 1982, the court upheld a challenge to a New York law that prohibited the distribution of photographs and films depicting children engaged in sexual conduct. As a result of this decision, child pornography, regardless of whether it is obscene, is not protected by the First Amendment because the production of such materials would not be possible without the abuse of children. And that was a case, New York versus Ferber in 1982. For the same reason involving abuse of children, the possession of child pornography is also illegal. In 1996, Congress amended the Federal Child Pornography Act, expanding the definition of child pornography to include materials that appear to be a depiction of a minor in sexual conduct. The Child Pornography Protection Act, Public Law 104-208. This included computer-generated images and adults portrayed as minors. This extension of the definition was found to be unconstitutional by the US Supreme Court in Ashcroft versus the Free Speech Coalition. That was because it was not, if there's an adult pretending to be a minor, for example. Now you have to prove that that's the case. You have to have proof, whoever is doing that, that indeed it is not a minor, if somebody challenges you. So that'll put an extra burden upon various services for that, but it's a reasonable one. So now, harmful to minors. Much of the controversy surrounding access to library materials on the internet is on the legal status of children. Many people believe that minors don't have the right independent of their parents. And in fact, the Supreme Court has recognized that minors do have some rights under the First Amendment. However, the court has also ruled that state legislation may specify some materials that are protected for adults as obscene for minors. There's no federal harmful to minors law currently in effect. Many states have enacted harmful to minors. Oregon actually is a very, very narrow one. If it's used for seducing a minor or abusing a minor, then it is unconstitutional. It's not as broad as many other states have in relationship to that. So privacy, and as we continue to get more scared about all of this, confidentiality and privacy. The right to go about one's business without one's activities being observed or examined by others. And confidentiality, and that was what we're particularly concerned about when we're talking about the proposal that I did before about our internet service providers being able to do exactly that. So why do we care? Well, as we're learning more every day, privacy is under attack. And we've gone through the whole controversy concerning the Patriot Act and the NSA surveillance, and the privacy of library records is in the center of the controversy. Former Attorney General Ashcroft called librarians hysterical when we were against this and went to court. So it's like almost everything else with difficult topics, and that is a balance has to be made. We have to get a balance between national security and individual liberty, as much as we have to get a balance between sexually explicit material and the harms that it might have to individuals. If we sacrifice our civil liberties in hopes of making ourselves completely safe, we will have sacrificed our defining characteristic in this country, liberty. So we just can't, we have to fight with it. And we're in the middle of it. Libraries are very much in the middle of this discussion. And luckily, most people love their libraries. So what's the basis of the fundamental right of privacy? How did it get to be put into the value of our system? I think it's good to know that we didn't just make this up. Librarians didn't just make it up. Even current people didn't make it up. Because it actually was based on privacy by the founders of the nation, because despite the fact that British legal theory recognized a man's home as his castle, British policies authorized general searches of homes. And that's one of the things that our founders sought to escape. If they were not in the right religion, particularly also, they didn't have any of this, a lot of the same rights that other English citizens did. So one of the strongest arguments for the concept that a legal writ authorizing a legitimate search must be specific to the persons and places in order to get a warrant to do that was made by Sir Edward Coke, who was part of the Institute of the Laws of England. As he lay dying in 1634, Privy Council agents searched his home and law chambers looking for seditious papers. They seized not only manuscripts of his legal writings, but also valuables, his will, and a poem addressed to his children. And he made a strong argument that went to the hearts of those who came to found our country. Many colonial settlers were outraged concerning the Crown's use of general warrants to gain evidence. And these writs of assistance, which would allow them for a whole year to be able to do things, were routinely authorized by the Crown. Again, they were called fishing expeditions. That's what we'd call them now. So on the eve of the issuance of the Declaration of Independence, John Adams declared that the argument concerning writs of assistance was the beginning of the controversy between Great Britain and America. The result, the 14th Amendment. Now, speaking of those amendments, should we ever wonder about how important the Bill of Rights is, we were to recognize that when the group that got together to develop the Constitution agreed with the version of it, they made a provision that the first Congress had to develop a statement of what the rights are. And that's where that came from. It was essential. Our Constitution would not have been adopted if the Bill of Rights had not been adopted. So it is very, very important. Although it didn't mean that after that went on that it didn't happen, for sure. For example, in 1770, the Pennsylvania houses of Quakers who had not yet taken an oath of allegiance to the United States were searched. That was ironic, I think. Books and papers were seized and more than 40 people were arrested and deported without trial to Virginia, where they were held until the next year. So, now the modern Fourth Amendment law relied heavily on Katz versus the United States, where the court held that the Fourth Amendment protects people, not places, and that a person seeking to preserve as private, even in areas accessible to the public, may be constitutionally protected. It's that privacy of your home concept. The two-part test is often used by the court to determine whether a right to privacy exists as expressed, for example, by Justice Harlan in his occurrence to one of the programs. A person has existed an actual subjective expectation of privacy. That expectation is when the society is prepared to accept as reasonable. And it is in accordance with the general assumption of what people expect. All right, now all of you should find out what your state's laws are in terms of privacy, because that is where it comes from. And they do differ, and sometimes greatly. For example, the confidentiality of library records in Oregon is an exception to the open government for being able to tell. But it's very important to know, and you should find out in your states if you're elsewhere on this, that it also requires that the library adopt that particular exemption. It has to be in the library. If it doesn't, then you don't have the right of it for library records. So it has to happen. The records of a library, by the way, defined in Oregon's protection, and you should look to see what kind of records the library are in your states if you don't live in Oregon, is the records of a library, including circulation records showing use of specific library material by a named person, the name of a library patron together with the address or telephone number of the patron, and the electronic email address of the patron. Not all states protect that many things. And in addition to that, the Oregon notations about indicating what this means is the 5-part test for determining whether information supplied to an agency in confidence is exempt from disclosure is whether information was submitted voluntarily. The agency can show the nature of information is such that information should be kept confidential. The agency has undertaken good faith obligation to maintain confidentiality, and disclosure might harm the public. So now, speech versus behavior. Oops, okay, here. I'm gonna go on here. So, a couple of ones too. What about violent speech in minors? Violent speech is protected speech unless it is directed to inciting or producing imminent lawless action, like calling fire, and it isn't a fire. It's likely to incite or produce that kind of action. A number of states and local entities have adopted laws or ordinances restricting minors' access to electronic games with violent concept. None were upheld by district or appellate courts, and in 2001, the US Supreme Court found California's law to be unconstitutional. It was Brown versus the Entertainment Merchants Association. So what about inadvertent viewing? Well, I love the case that dealt with this. There's Nazanin versus the city of Jacksonville. Family were driving down the street, 2 kids in the back seat, and they drove by one of those outdoor theaters and saw a naked person there. And so they filed a case against that, tried to get them to be done. And this is what there's Nazanin versus the city of Jacksonville case said. The plain as if sometimes disquieting truth is that in our pluralistic society, constantly proliferating new and ingenious forms of expression, we are inescapably captive audiences for many purposes. Much that we encounter offends our aesthetic, if not our political moral sensibilities. Nevertheless, the Constitution does not permit government to decide which types of otherwise protected speech are efficiently offensive to produce production for the unwilling listener or reviewer. Rather, avert your eyes. So, now the children's internet protection now. Yes. I actually, in the combined court with that particular case, was a witness. I was the first witness for the American Library Association. Only the court would not allow the American Library Association to have me, so they asked me if my library board would do that. I worked for Fort Vancouver Regional Library at that time in Washington State, and I had to go and ask the library board if in fact I could represent them. And they said yes. The reason was that they were beginning to work on an internet policy, and they did not think it appropriate that they shouldn't be able to make the decisions that went with their community. It was a very interesting circumstance. I got helped by the attorney that ALA had, and he put me through this thing of asking me questions, and demanding that I go like that, because they said they'll try to trip me up. They'll look up and they'll see a gray-haired woman and try it, and they did actually. They did actually. One of the government's one, they put this picture, from I forget what it was, for a book. I said, yes, my library owns that book. I was really glad we did. And finally the judge said, stop harassing her. And in that particular case, we won. It was found to be unconstitutional. Then it went to the US Supreme Court, where it was not found to be unconstitutional. But what most people have not, who put that as kind of broadly meaning, have not actually read the decision. Because particularly in relationship to adults' right to access, if if you have internet filtering, that a librarian should have the ability to take the software away so that an adult can have full access. And also the circumstances about remembering what I said about what unconstitutional speech is, that there's also a need for libraries to pay attention to what their filter is actually filtering out. Because many of the filtering groups who originally developed their software for families to use, used criteria that would not match a constitutionally accepted one. So it is very, very necessary that libraries constantly pay attention to what's being blocked. And actually the vendors should be required to let you know what the categories are for being blocked. They put things into broad categories. And it is the librarian's responsibility, the library director's responsibility, the library board's responsibility to ensure that they're not overprotecting. Now, of course, if a library does not accept E-rates or federal grants, then it is not required to comply with SECRA. And there are libraries like Multnomah County Library that do not take that money. They do put filters onto children's. They can, a child or a parent with a child can ask that it's being overbroad and have it be released. So there are many ways to handle this, and it is really up to the individual library in terms of how we're doing that. So there are some guidelines to protect the rights of patrons to choose the lowest default level of filtering possible, to minimize the amount of protected speech that will be blocked, develop a procedure for disabling the filter for an adult, as I mentioned, develop a procedure by which a patron, adult or minor, may request that there is an inappropriate block site, notify library users of their right to request or disabling or unblocking. And there is nothing in the law that prohibits offering voluntary choices of greater filtering levels. You can actually, we did this for a while at Fort Vancouver Regional Library. It's a long time ago. I don't know whether they still did it, in which a patron could attach to their library card number that they wanted a greater filtering. And I'm assuming that's still available. That option might still be available. So, unfortunately, the SEPA decision still has problems because parents lose some of the ability to control their own children's access. They cannot, in relationship to being able to have more access. Now, there was an applied challenge to North Central Regional Library in Washington State in 2006. Bradbury versus the North Central Regional Library District. That was when I was working in that particular part. And it's often cited, or used to be cited in Washington State as a requirement to have, they had very high filtering in that library. But the fact of the matter is that it was a federal district court and it was an unpublished decision, and unpublished decisions have no authority in terms of that. In a lower court, you can have an unpublished decision because it's not going to have a major, at that level. If it goes to a higher level, it will. But at that level, it applies only to that entity, to that particular place where it was. So you can't give that same kind of importance to it. Okay. There's another case called Kathleen versus the City of Livermore that raised the question of whether there's a liability for offering unrestricted access to the internet. Is that a problem? In this case, the answer to it was that in this case, we hold that a city is not subject to suit for damages or for injunction for offering unrestricted access to the internet through computers at a public library. Again, this ruling applies only in California because it never went to a higher court, but it's still, I think, of interest in relationship to possibilities. So, again, there's a question, is there a civil liability for an alleged hostile work environment related to patron internet use? Can an employee sue their library because they are offended by what they happen to see. And this, in 2001, the Equal Employment Opportunity Commission released a finding of probable cause that 12 Minneapolis public employees were subjected to sexually hostile work environment, and mediation was not successful. It was based on the particular employment context of it. It did not automatically apply to any other library. And even a final judicial determination based on the facts can't be binding on any other. And actually, the Civil Rights Division of the Department of Justice declined to pursue on behalf of the librarians. The complainant alleged that they were seeing images from them, but they settled it finally. And the library agreed to implement a centralized location for internet printing. It was the printing that was causing the problems. People would print. So having a centralized place where it goes, where they have to go pick it up, was considered by the agency to say that would work. Okay, so, and it's important to avoid being caught in a situation like this, to utilize software that reboots the computer and clears the cache in history when a person shuts down, that configures printing in a way that minimizes inadvertent, and to inform patrons that access to illegal materials is prohibited. Just put a little sign up to say that. So it puts the responsibility onto the patron. So, how much time is it that we've got now? Okay, so we're sort of getting, I think it's time to offer the chance for you to ask me questions. Yes?
I was hoping that you would talk a little bit about intellectual freedom as a foundation of democracy. And I know that one of the greater concerns that our community has now is the impact of searches on immigrant rights. I mean, even more than child safety and pornography.
Yes. Yeah. Very right. And I think it's the same kind of conditions would apply. It clearly it's connected to democracy because of the requirement that the Bill of Rights could not be, it had to be there. And it's the Bill of Rights that provide the protection. It's the Bill of Rights that is the underlying factor of our society. So that would be true. So the second question was about?
Well, just in terms of
immigrants. Yeah. That is a very complex situation. However, I am fairly confident that at some particular point, the kind of action that's taken with no reason against immigrants right now will get its way to the courts. Now, of course, because we don't know who the next justice is going to be to come, we may go through a very bad time. There are serious concerns in relationship to the way the Supreme Court is going. But so I can't, promise anything there. But at the moment, to deport somebody without, and including somebody who had a visa to come here, for example, I mean, it's working its way through. And I think librarians and libraries have to be absolutely certain that they don't get caught up in that. Yes.
Have you heard any instances of ICE trying to work through library systems in order to gather information about undocumented immigrants?
Not specifically that, but we've had many instances in which governmental agencies and police departments and all of that, and that same policy, but your library has to have a very strong protection of the privacy with an indication that you will not release it to anyone else. That should be part of your policy. Yes.
I have a question about school libraries, especially like K-12
yes.
libraries in relation or as in comparison to public libraries. Because when I think about censorship challenges and internet use being filtered in school libraries, I feel like it's much more restrictive than in other library settings. And so I guess I was wondering, are school libraries subject to those same laws? And
well, they are, but it's complex. For example, when we went to SEPA, we tried to get the school library organization to join us because that's who controls. It's the libraries. It's very different than the library itself. And they didn't even respond. They refused to do that. But I have gone to participate in at programs that the Oregon Intellectual Freedom Committee has put on in school libraries, and had some really interesting discussions with the people who came. They have lots of challenges, but one way to consider, and this would have to happen with in relationship to that school and its rules, the general school, not just the library, about the protection of privacy. And there are lots of schools that I'm familiar with that actually have gone through that process in order to get reasonable protection of privacy in relationship to school libraries. But it's a problem. There's no way around that.
So could a student theoretically sue a school or a school library on the grounds of their intellectual freedom being
Yes,
compromised?
yes. There have been ones in which a school, for example, refused to set an age level for materials that were actually age appropriate and refused to check it out, that have gone to court. Particularly there are cases dealing with sexual kinds of things, definitely so. Now, before any more questions, before anybody asks me this, but maybe you won't, what about private libraries? Well, private libraries are not like religious ones, for example, are not covered by that. They do not fall within a government agency, and so the government agency. But I want to tell you a story because I think, I'm not going to give the name of this person or that library, but he is an Emporia graduate. In fact, he was a student in one of my classes. He works for a very conservative, Perry's smiling because she knows who this is. He works for a very conservative Christian college. And he also said he was never going to be a library director. I taught management at that time, and he says, Perry says I had to take it, but no worry. So some number of years ago, I got a message from him, and guess what? I'm the library director. So that particular library also serves the families of the people who are there. And I suggested, I didn't know if this would work, but I thought if anybody can make it work, and then he could be a model. If you talk to the fact that what the purpose of a religious college is, or a high school college, but religious, is to not only give them a general knowledge and information, but also to be able to defend the faith. And if they're going to defend the faith, they need to know the opposite sides from which they are defending it. Because if you take action without knowledge, then you have a problem. So therefore, there needs to be a place where there is such access. And the librarian doesn't stand at the door and force them to take out. The choice is made by the student who's coming in to look. And so there have been several arguments about that, and he hasn't talked to me a long time. I think he doesn't even need any more help. In fact, he's actually on the Intellectual Freedom Committee now, the Oregon Library Association. But he negotiates and has actually almost always been able to be effective. So I think that's an approach to share with those libraries. And libraries like the Jesuit, and the various other libraries here in Portland actually participate in Banned Books Week. So I'm figuring if they're participating in Banned Books Week, then they're obviously recognizing the important. And what's interesting about, really good also about our Banned Books Week here, is because we have the Intellectual Freedom Clearinghouse, which by the way would lose its funding and if that, is that we know what's being challenged in Oregon. And I hear from the librarians, school librarians, that the kids get really hit by that when they realize this has been challenged in Oregon. And it works to get them interested. And the school librarians in Oregon are getting in every year they were a little uncertain when we first started sending them the buttons, and at the ACLU is the one who started this. When I was president, I suggested it. They wanted to have something that they could do all over the state, because they don't have presence very much elsewhere, and I suggested that. But the school library, they do skits, they do all involving the kids. They have them draw posters, and it's a fascinating situation in terms of that. Yes.
There are some questions sent into the chat.
Okay.
So there's two. So the first one is, can you speak a bit to striking a balance between intellectual freedom and social responsibilities?
Well, I would like a definition of what they mean by social responsibilities.
So let's go to the second one.
Okay, that's too general a thing for.
Okay, it says, how would you respond to librarians who say it is not the place of the library to participate in politics?
Well, particularly if you're a public library, it depends on your state laws in relationship to that, because usually that is established as a state law and returns to that. And when I was working for Fort Vancouver, we had libraries that were actually in small towns that would have a political debate between people, because that's the only place where people could go to see. And that was prohibited. So we went to talk to the agency that does that and got an exception for public libraries if they offer an invitation to all the candidates. But if candidates do not come, then they can still do it. But they have to offer that to do. And in relationship to some libraries, and this is not, as far as I know, in Oregon at least, or in Washington, is that you could allow people in an outside place where they can put things down. People, well, sometimes they say no, nothing commercial, but things that individual organizations would like to share with the public, that it could also include that, but it has to be open to everybody. But you don't have to go out and demand that somebody do it in terms of that. So you need to find out what your own particular circumstances are with both your city and your county as well, in terms of what allows that. So did you get any more about the?
Yeah, it said specifically social justice. So can you speak a bit to striking a balance between intellectual freedom?
By social justice, do you mean things about race and religion? And that's such a broad term. And now, so yeah, in relationship to religious materials in a public library, that has come up from various times. Things books that advocate for a particular religion, and the way we. Yeah, okay. So, yeah, all right, that's right. So, one of the biggest arguments for the fact that, in fact, you should not exclude those from a library collection is if you're going to fight something, if you're going to understand it, you need to be able to go to a neutral place to find out about it. And the library is the mutual place. And nobody requires you to check out anything, so you can avert your eyes as you go by, if you wish. So that's the point of the library is to allow ways for people to make their own decisions. And so I would say recognizing that you make every effort to, I used to ask the branch librarians in Fort Vancouver to make a big effort to go to organizations where some of them are providing materials they'd like to have in the library, to ask them to also provide materials. Yes.
I know with some of the issues now with deporting illegal immigrants, is that some of the smaller rural libraries were having a problem, and it might be what some of this is getting at.
Yeah.
They were trying to be helpful.
Mm-hmm.
Helpful.
Yeah.
And then there would be people in the community that would get very angry.
Mm-hmm.
So you had these reading lists or whatever.
Yeah.
Agencies that would help you if you got legal help. Legal here, that there were other people in the community that would be angry that the library was using time and resources to, in a sense, promote something that they didn't
Right.
So I think that kind of comes.
It is, and I think then you can use the conversation by talking about all the other things that various people would like not to have in the library, and realize again that they don't have. They don't have to be there. And yeah, it is interesting. And
one suggestion was to say, well, we were asked. This was a need somebody brought to us.
Yes.
And we were asked to do this, and that's why we did it. So I thought that was an interesting
right.
way to
And the librarians are not the police. I would say that. Librarians are not the police. They're not immigration. They're there for everybody who appears, and they don't question, and not to be questioned. So that, I think it would make, we're not the ones to do that.
Maybe you could talk about the difference between, I don't know if this is all right or not, but between a citizen and a person. So some laws apply to all.
Yes,
persons.
that's right. Yes, they do.
They're not, they specifically don't say all citizens.
Yes, right. That is true. Because we have people that come to live here that never become our citizens. And they still have rights. They don't have the right to vote. I mean, that's an element that is legitimately not done in relationship to that. Can't serve on a jury. Those are the two things that are definitely for sure. Yes.
Sorry, there's another question.
Okay.
What is the line between advocacy and activism? Is it ever okay to cross?
Are you talking about for libraries or? Yeah. That is a little, it's in the eye of the beholder in a way. And again, sometimes it's subject to state law. If in fact they say that in a public entity, for example, there's a whole issue of coming to work with a candidate's name on you, and therefore you're doing for that. And I think it is not illegitimate to say that you cannot wear that particular button because it connects it with the library. So that I would say would be something that would be beyond the tune, very definitely. But if people are standing outside the door of the library, even if they're employees but they're on break, for example, I've done in that because I stand when Multnomah County Library is having a measure come. I will come and stand in front of my library and with all information about it. Now, I don't work for that library, but sometimes library staff members take off their buttons, take everything that identifies them with that, and they're on their lunch break or a break, come out also. And they also kind of agreed that they would not identify themselves as being a library employee when they were doing it there, because they're also citizens. So I think one needs to just make sure in analyzing each of these circumstances about the difference between you as your worker when you're working and when you're a regular citizen, because you are a citizen.
I guess they added on behalf of patrons, what can librarians do? I guess the difference between advocacy, activism, instead on behalf of librarians and immigrants.
Yeah.
What's appropriate as a librarian and what's not.
Well, as a librarian in general, you are still a human being and can make those circumstances. And if your library is not checking, not in any petition when the direct local government requires you to, I'm going to forget about what some people say, some person says, I should say, and in relationship to what those requirements are. So.
Multnomah County is a sanctuary city.
Yes, it is.
So our platform politically is probably different than campus.
Yes, exactly. That's why I say you have, yeah.
You probably have more freedom to do stuff.
Right, right. And, and it's possible, one of the reasons I really like that this is a Kansas-based is because I am amazed at the opinions of my students that are there. They are adamant because they live sometimes in an environment that is difficult for them, and it makes them much more courageous in what they do. Book challenges, we haven't talked about that, and I do want to tell you an amusing story. I had a good friend, he was in Washington State, and he is a devout Christian. In fact, I think he's a minister. He's in one of those ones, and he's also a minister as well. And he loved to tell the story, which said a lot about him, is he had somebody come in challenging a book, put it down and say, this is just outrageous. This is horrible. Should not be in this library. He said, and this is what he suggests to other people too, is to say, can I help you find something more pleasing to you? The person, this particular person said, oh, yes, thank you. So I'm recognizing that somebody that comes in challenging a book is just upset, and because they got something that offended them, that doesn't always work, but it's the first try. And then if it doesn't work, then you'll have to tell them about what has to happen. In other words, that they would have to make a formal complaint. We have a form. This is the questions we ask you. And we have a procedure, and this is what our procedure is in terms of determining if you're out. Yeah.
Have we fetishized intellectual freedom to the point that we cannot redefine our purpose as information professionals?
No. Because that is what an informational professional is in the library, is to make sure that everybody can have access. And because lots of things that are not directly related to libraries, but it put individuals in positions that they, like there was a particular, been some incidences of which somebody that who's on parole couldn't use the library. And that was in another state. And they actually brought that up and won a case in terms of that. I don't remember where this was. Because if you want somebody who has been imprisoned and then wants to get back into life, they have to have a means of informing themselves, a means to be part of the community. And if you cut them out, you've made a much greater chance that they're going to just say, why not go to prison? So, yeah. It's a hard profession sometimes, but a rewarding one. Oh, I'm sorry, yes. All right, you can't all take the course, but really, 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 you should buy these books. The first one is the Intellectual Freedom Manual. The other is a history of ALA policy on intellectual freedom. And I will tell you, but I never got paid anything for it, that I actually co-wrote this with Judith Krug, who was the founder of it. And I did, I contributed to this one by doing the terms. It's a definition of the terms being used. These books, you know, that's why it's so important to know that the history of intellectual freedom tells you that it was slowly adopted as things moved in. It was not immediately the purpose of the American Library Association. As it began to be problems in terms of censorship and all of that, they jumped in and completely reversed their approach. So librarians in the library profession, historically, is just like anyone else, any other organization. You figure out what people need and you change as things change. Any other question? Okay. And if this is not your first year, perhaps I will be hired to yeah, to teach it again. Well, not every library school has a separate intellectual freedom class. It is taught in collection development, et cetera, et cetera. But I think there is a good advantage to be able to put it all together in some place.
It's one of those generalist skills that applies to everyone. I agree. A sting on all the groups is
Mhm. So,
I'm gonna go ahead and stop recording. Yeah. Oh, we got, yeah, we got. Okay.
so,
We'll reconvene at
Hi,
1:30.
thank you so much.
Oh.
I gave a presentation on intellectual freedom.